tier for my mama kwaba and fambra a channel issue. Now me some notification button not turning on in case any update baby beer on to Sabe Kanwashi. Maybe beer I come.
Trending conversation about constitutional amendments, and our friend Kwame A Plus contributed to it on UTV. He said something about the constitutional amendment in terms of this conversation about does President Mahama want to do a third term, etc. There are conversations about it, and A Plus spoke about it on UTV. As a member of parliament, of course, we take him very seriously. This is what he said. Let's listen.
Justice Soa, to forwards Attorney General, ne judgment no or throw when we say constitution no, and yet just text to send it that way. You are why
me them is so honorable Kawasam
first year. I say a living organism capable of growth. Ain't no constitution no, I will say any and yes say attract one and one no. So if the president thinks that the term limit no M1 Ghana obey to meet the constitution now call parliament say parliament me feel say Ghana no I will say a term limit free so udi 100 terms kwana ko fon so mpewa also what transfer development e yamra da ho enye do mama de hye say amra no
but for now dear
no do mama on make as ba me pese ade no ko obi atrim say ni ayeye dede say do mama petete omo ye lawyer for omo nim ni amra ne ka amra ne say John Mahama feel so person or tena so bi mu a on famra parliament obo ba beto yen wo ho yen ne be hwe ade no aka say okay emra no ampa ya change mra na yen say wudi president obetumi edi akọ say obewu ana say say kura yen to aba wo Ghana ye betumi akọ parliament aye mra say Ghana kura yen to aba bi
I think that
make as ba me pese ade no ko obi atrim say ni ayeye dede say do mama petete omo ye lawyer for omunim ni amra ne ka emra ne say John Mahama feel so person or tena so bi mu a on famra parliament obo ba beto yen wo ho yen ne be hwe ade no aka say okay emra no ampa ya change mra na yen say wudi president obetumi edi akọ say obewu ana say kura yen to aba wo Ghana ye betumi akọ parliament aye mra say Ghana kura yen to aba bi.
I think that he forgot a few things we just want to add. Kwame, how are you? I'm saying we refi near maybe or somehow kind of ukasa ye but we refi near maybe into my fancy my why. Let's get onto the touch screen and understand. So the point he's making is that the president can take the constitution to parliament and ask for an amendment. That's not quite true. Okay. So he's claiming that the president's term limit can be amended in parliament. Is it true? The verdict is no, it's not true. Why is it not true? Presidential term limits are governed by Article 66 of the Constitution, which provides as follows. 66.2, and viewers, you can read it yourself. Article 66.2. It says, a person shall not be elected to hold office as president of Ghana for more than 2 terms. So that's the article that we are talking about, being amended and not being amended and all of that. So the issue is 2 terms. Does it mean consecutive 2 terms? Does it mean 1 term here, 1 term there? So that those who think that President Mahama can do a 3rd term, they are saying that this article doesn't say that it is 2. This article means 2 consecutive terms. If he hasn't done 2 consecutive terms and he did 1 term, somebody came in, he did another term, somebody came in, he can do another term. That those who are limited to 2 terms are those who are doing 2 consecutives. That's one after the other straight away, 8 years straight. And it is them that this limitation is imposed upon. Let's read it again. A person shall not be elected to hold office as president of Ghana for more than 2 terms. Now, Article 66 is within Chapter 8 of the Constitution, which is a chapter that is entrenched. And that's where A Plus left a few things out. This article is entrenched. And so Parliament, I'm sorry to say, viewers, Parliament, including all their 276 members, have nothing to do with changing this. So if he says the president can bring it to Parliament, that's not quite true. Parliament, I'm saying it again, Parliament has nothing to do with amending Article 66. Nothing. In terms of the MPs voting, their decision making, no. Parliament is just a platform. The MPs don't have any role to play, whether they will vote, they will look at it. It has nothing to do with it. Let's see why it is so. Okay. What are entrenched clauses? These are provisions that contain elaborate measures which include popular participation, etc., etc. So entrenched clauses, they are not amended by Parliament. Parliament has no role to play in it. Who then have a role to play in it? Let's look at it again. All right. So these are some of the examples of entrenched clauses. Article 1, Article 2, 3, Territories of Ghana. Article 11, the fundamental human rights. Article 5, representation of the people. Article 42, 43, 46, etc. The executive, Chapter 8, that's where the President Mahama and the A+ conversation is. And then the legislature, Article 93. Okay. Now, all of those articles that are entrenched, including the presidential term limits, they are dealt with by Article 290. 290. So let's look at it. Okay, Article 290. Now, this is the important thing, viewers. Let's take it slowly. 1 minute, I'll finish. A bill for the amendment of an entrenched provision shall, before Parliament proceeds to consider it, be referred by the Speaker to the Council of State. So a bill, so you have to send a bill to Parliament, and usually the bill will be in the name of the Attorney General. Such a bill, constitutional amendment, will be in the name of the Attorney General. So the Attorney General takes a bill. So a bill for the amendment of entrenched provisions shall, before Parliament proceeds to consider it, be referred by the Speaker to the Council of State for advice. And the Council of State shall render advice within 30 days of the receipt of the bill. So viewers, you are getting it. Council of State has the first role to play. With Council of State members, they will look at it, their intention to amend an entrenched provision, which is contained in the bill. Council of State will look at it. Parliament doesn't look at it. MPs have no role to play in it. So please tell Kwame that he has absolutely no role to play in a constitutional amendment of an entrenched provision. So Council of State will look at it first. When they finished, it comes here. The bill shall be published in the Gazette, but shall not be introduced into Parliament until the expiry of 6 months after the publication in the Gazette. So the next thing is that when Council of State have looked at it and they think that the advice on it, they are giving it a positive green light, Council of State can give some different advice. But if they give a positive green light, then it is published in the Gazette. Let's see what happens next. After the bill has been read the first time in Parliament, it shall not be proceeded with further unless it has been submitted to a referendum held throughout Ghana and at least 40% of the persons entitled to vote voted at the referendum, and at least 75% of the persons who voted cast their vote in favor of the passing of the bill. Where the bill is approved at the referendum, Parliament shall pass it. So viewers, we get the steps. Council of State will look at it. Then it comes to be gazetted. After it's gazetted, it's laid in Parliament. When a bill is laid in Parliament, there's no conversation. In fact, the thing says that it shall not be proceeded further with. The order here is that when it's laid, Parliament should do nothing about it. They should just send this electoral commission process. When it gets to the referendum and you're looking for an amendment of Article 66, you have to be sure that if the voters register is 10 million people, 40% turn up to vote. At least 40%, it could be more. So 4 million people turn up to vote. Of the 4 million people who turn up to vote, 75% must vote for the bill. So if 8 million people turn up to vote, 75% of 8 million must vote for the bill. If 7 million people turn up to vote, 75% of 7 million must vote for the bill. This is the law. This is what it says. So it's not that the president can take the constitution, take it to Parliament to amend for Parliament to look at it. Members of Parliament have absolutely no role to play in a constitutional amendment process. Kwame, so that's okay. We love our MPs. We need to rely on them. But sometimes when they are doing public education, they need to do it right. So that's the end of our story on this one. Constitutional amendments. I'm sure we're going to be talking about this going forward for many, many years, many months, I should say, because there's an edge. Some people want to look at it. And it's a part of our constitution that we may have to test. The other way, there's another way. The other way is to go to the Supreme Court and ask the Supreme Court for an interpretation of Article 66. And the Supreme Court may interpret Article 66 to mean that somebody can do a third term or somebody cannot do a third term. So you can use the Supreme Court's route. So that's also available, and we are looking at it and checking out. I hear that some people are even preparing right now to take a matter to the Supreme Court, asking for a declaration that on the true and proper interpretation of Article 66, an individual cannot do more than 3 terms in whatever circumstance, cannot do more than 2 terms in whatever circumstance. I don't know where that bill is, but I think they are taking it to the Supreme Court. So that's our story for today. We'll be right back.
This dramatic entry into this restaurant at the airport's residential area. Gabriel Scott Poaman was there. Asiedu was there. Who's calling me? I'll call him back. Somebody's calling me. Oh, boss. Okay, I'm on TV. Hey, this matter is getting hot too. All right. So Gabriel Scott Poaman was there. Asiedu was there. And who's the third person? Justice Kulendi, who is not sitting as part of the committee. He's not. He's a very distinguished Supreme Court judge, Justice Kulendi, on the left of your screen. Justice Kulendi was also there. Now, why is Justice Kulendi important in the allegation or the allegation of collusion? Because Justice Yoni Kulendi was one of the 3 judges who gave that expert opinion blocking the injunction that had been filed to injunct the committee's work. There was an injunction filed by the Supreme Court to injunct the committee's work on the basis that President Mahama had jumped the step of not giving Justice Tokonu the document. Now, that Supreme Court's decision was a 3-2 decision. 2 of the judges agreed with the applicant who filed the injunction, Mr. Asifo, a member of parliament. That application was argued by the Leonard Godfrey Dami, the former Attorney General. Now, Justice Kulendi ruled on the side that the injunction should not fly, and he was with the 3 and the 2 others. So Justice Kulendi, according to the story, was part of this dinner. And then Mr. Tadio Sori was also part of the dinner. The problem here, the allegation of the problem, that if all these facts are true, then there should be some concern as to why Justice Scott Tweaa, who is chairing the committee, and Justice Asiedu, who is the other Supreme Court judge on the committee, are seen together with Tadio Sori, who is counsel for Daniel Ofori, and which Daniel Ofori has had a major tussle in the court over this EcoBank matter for a long time. And then on most of the Daniel Ofori tussles, Gabriel Scott Tweaa has ruled in favor of Daniel Ofori, and Daniel Ofori has perceived Justice Tokonu as a major enemy in his quest to secure $97 million Ghana cedis from EcoBank. Daniel Ofori perceives Tokonu as an opponent to this matter. Tokonu has her reasons for opposing the matter on the basis of law, on the basis of calculation of compound interest, and all of those matters. Justice Tokonu has a firm, clear view on that matter because she came out of the commercial court and she's well versed in these things. But let's leave that for now. So this is the reason why eyebrows could be raised if it's true that all of these 4 men had met together having dinner on the same night after the committee refused to hear Justice Tokonu. This is the story. Now, the petitioner went to the president and petitioned, and the radio newspapers were carrying the story. And so this morning on his Facebook page, can you put that? Thank you very much. On his Facebook page, Tadio Sori wrote this: "It is a monstrous lie. No such meeting took place. It is very easy to fact check that. We know those who get justice through negotiation." I don't understand the second part of Tadio Sori's thing. He says, "We know those who get justice through negotiation." I'm not sure who he means or what he means, but he's a very senior lawyer. So, I mean, I know he knows what he's talking about. But the fundamental thing that Justice Sori says here is that there was no such meeting took place. In Justice Tadio Sori's comments, we don't know whether he means that he was not at the restaurant, or that he was not at the restaurant that day, or that he was there but the other judges were not there, or that the other judges were there and he was not there, or that he left before the other judges came, or that they came before he left, or that they were all there at the same time but they just talked about something, or that he was there and he met somebody else and the judges were together somewhere else. We don't know all of those details. So on this note, let me go to the petition and let's see what the petition says before we go to speak to the petitioner at 25 minutes past 11 o'clock. Let's get the petition now. So the petition is P.O. Box 622 Adenta, Accra, 19th May 2025. His Excellency John Dramani Mahama, President of the Republic of Ghana, Jubilee House, Accra, comma, Your Excellency, comma, read petition for the dissolution of committee formed under Article 146 of the Constitution to inquire into the petition against the Chief Justice as follows. Is by Mr. Kumi. Respectfully, comma, I'm a citizen of Ghana and one with keen interest in the protection of the Constitution, particularly all steps taken by the President in furtherance of his duty to execute and maintain the Constitution and the laws of Ghana pursuant to Article 58(1) of the Constitution of Ghana. On 22nd April 2025, the spokesperson to the President informed the nation of the composition of a 5-member committee under Article 146 of the Constitution to inquire into 3 petitions for the removal of the Chief Justice, Her Ladyship, Justice Gertrude Araba Isaba Tokonu. The members of the committee were stated as Justice Gabriel Scott Tweaa, Supreme Court Judge, Justice Samuel Adibu Asiedu, Supreme Court Judge, Daniel Yao Lobdom, former Auditor General, Major Florence Bazwanura Dalugu, member of the Ghana Armed Forces, Professor James Sefa Jifa, Professor, University of Ghana. That's the 5. The spokesperson to the president followed up with another press release on 14th of May 2025, in which he indicated that the committee will hold its first sitting on Thursday, 15th May 2025. Respectfully, I deem it my duty to bring to your attention the conduct of some of the members of the committee set up by your good self, which clearly has compromised their fairness and has brought the committee into disrepute. In the evening of 15th of May 2025, between 7:30 and 8:30 p.m., Justices Gabriel Tweaa and Samuel Kwame Adibu Asiedu, together with Justice Yoni Kulendi of the Supreme Court of Ghana, were seen having dinner with the counsel for one of the petitioners before the committee, Mr. Thaddeus Sori, at the Santoku restaurant located at Villaggio Airport Residential Area, Accra. The strange meeting of the 4 persons who are keenly interested in and have played and indeed continue to play critical roles initiated in the processes for the removal of the Chief Justice excited the curiosity of some persons in the restaurant. Indeed, they were overheard discussing matters relating to the petition. Respectfully, the record of the presence of the 4 justices, Tweaa, Kulendi, Asiedu, and lawyer Thaddeus Sori at the restaurant and the meeting they had can easily be verified and confirmed. I like that. The above development is of grave worry, as proceedings for the removal of the Chief Justice of the Republic of Ghana is very solemn and serious process and should not lend itself to manipulation by any person or authority. The meeting between Justice Tweaa, Kulendi, and Asiedu with Thaddeus Sori clearly has destroyed the integrity of the process and reduces public confidence in the process so far. Both Justices Asiedu and Tweaa are members of the panel set up to inquire into the petition. They have no business meeting counsel for one of the petitioners outside working hours at the unofficial place, a restaurant, and to have a discussion. This is more serious when the record shows that Justice Tweaa gave judgments in favor of the same petitioner, Daniel Ofori, represented by the same counsel, Thaddeus Sori, in Supreme Court. Justice Tokonu, the record shows, rather gave opinions against the said Daniel Ofori in one of the cases. Further, Justice Tweaa is known to be interested in becoming the Chief Justice following your election as President of the Republic. That's interesting. The petitioner is telling the President that, Mr. President, but you know that Justice Tweaa, since you became President, he wants to be Chief Justice, you know. But that's really what he's saying. Mr. President, why? You don't know. You know that Tweaa wants to be CJ, you know, because you were elected, you know that already. All right. Justice Yoni Kulendi is widely known to have been a close rival of Justice Tokonu for the position of Chief Justice when same became vacant after the exit of Justice Kwesi Eniyeboah. He, Kulendi, lobbied vigorously for the position but was disappointed by President Akufo-Addo. It is therefore not surprising that he voted with alacrity against the plaintiff Vincent Ekwa-Asefua to dismiss an injunction application filed by him to restrain the taking of further steps under Article 146 until the suit filed by him to challenge the process is determined. Clearly, he has an interest in seeing the exit of Justice Tokonu as Chief Justice. He is known to be interested in being appointed Chief Justice. Justice Samuel Kwame Adibu Asiedu is also on record to have been one of those who actively lobbied to be Chief Justice after the exit of Justice Eniyeboah. He was also, however, disappointed by President Akufo-Addo on account of being far junior in the Supreme Court at that time. He thus has a personal interest in the removal process underway. Respectfully, in view of the matter set out above, the membership of Justice Tweaa and Asiedu of the committee set up by your good self is an affront to justice. The meeting they had with Thaddeus Sori at Santoku restaurant on Thursday, 15th May 2025 clearly brings the administration of justice in the 3 petitions into disrepute and compromises their ability to efficiently discharge their duties to the Republic under Article 146 of the Constitution. Their conduct is deplorable and most unbecoming of justices occupying the highest court of Ghana. It has therefore the tendency to show that the whole process, quite unfortunately, is a sham. In the interest of preserving the integrity of the process I hereby petition you for an immediate dissolution of the committee as